A day after the head of state issued weighty submissions toward the judiciary on the BBI, a 7-judge bench is expected to hear the submissions of the BBI appellants who seek to overturn the High Court ruling that nullified it.
A 7-judge bench is set to scan the BBI bill that sought recourse at the Court of Appeal after a verdict from the High Court labelled it null and void. The wider Court of Appeal bench of 7, a step up from the 5 of the High Court that made the ruling, will be led by Court of Appeal President Justice Daniel Musinga and will commence on the 29th of June through to the 2nd of July.
The record of appeal having been filed, the above appeals are hereby consolidated and shall be heard together, and the lead file shall be E291 of 2021.
President Uhuru Kenyatta's sentiments on the judiciary during yesterday's Madaraka Day celebrations would not escape untouched, being termed as undermining public confidence in the judiciary by a section of lawyers.
If the court had subjected its decision to stop BBI to a cost-benefit analysis, in other words, if it had considered the burden of choice, then there are questions the judiciary would have asked. If we indeed were at a constitutional moment, is a decision against BBI a decision in support of the status quo? If BBI were to be stopped, who carries the burden of choice?
Apart from heaping praise on the bill, the seemingly agitated president said that the judiciary ought to consider the spirit of the law in the execution of its decisions.
As I said of the judiciary, their decisions must consider the letter of the law, but fundamentally, the spirit of the law must also guide them. I say so with all humility because the spirit of the law is the light that will illuminate the burden of the choices that they make.
Justice Musinga, however, called for respect between each other to allow the proceedings be conducted with the required dignity.
We want to be fair.